Welcome back, everyone. Thank you so much for tuning in to our very insightful morning panel on free speech and education and all of the surrounding issues that entails. Our second panel today will address the concept of free speech in the ever-evolving space of social media platforms. The use of social media platforms as a medium for political communication by government actors has grown exponentially. While online platforms are not legally regarded as public forums, panelists today will discuss whether they should have some obligation to not remove users' speech under First Amendment values, if not the law itself. Platforms have swung from a complete refusal to regulate online content to a total block of a US president and representative, all in the name of the right, or lack thereof, to pick and choose content. But where does this right start or end? Today's panel will address why the Trump lawsuits may surpass a state actor doctrine, what makes a platform a state actor, the Supreme Court case of the Snapchat cheerleader, and where platforms can go from here to protect users and the public. Our panelists today are joining us from all over the country to discuss their work on this topic, and I'm very excited to host each and every one of them. As I mentioned this morning, in the interest of preserving the most amount of time to today's conversation, I will keep the introductions brief, but all of our panelists' bios can be accessed on the Symposium's website. First joining us today is Professor David Hudson. Professor Hudson is an esteemed author and assistant professor of law at Belmont University College of Law. He serves as Justice Robert H. Jackson Legal Fellow for the Foundation for Individual Rights in Education and a First Amendment Fellow for the Freedom Forum Institute. Second is Professor David Green. Professor Green is an adjunct professor here at USF, as well as the Civil Liberties Director and Senior Staff Attorney at the Electronic Frontier Fund. Professor Green has significant experience litigating First Amendment issues in state and federal, trial, and appellate courts, and was a founding member of the Internet Free Expression Alliance. Joining us third is Victoria Vilk. Victoria is the Program Director of Digital Safety and Free Expression at PEN America, where she leads initiatives on free expression issues, including developing tools and strategies to empower writers, journalists, and media organizations to defend against online abuse. Moderating our panel today is USF's Dean and Professor of Law, Dean Susan Freewald. Prior to her position as Dean here at USF, Dean Freewald received the School of Law Distinguished Professor Award, published numerous law review articles on the regulation of online surveillance, and briefed and argued major cases involving Fourth Amendment protection of new communication technologies alongside the ACLU. Dean Freewald, I will pass it to you to lead our panel. Thank you.
Thank you so much, Lila, and it's a pleasure to be here. Thank you to the University of San Francisco School of Law for hosting the symposium, and thank you to Kenji Quijano for his always tremendous work in making these events happen. And thank you so much to our panelists for being here this morning in San Francisco still, and afternoon elsewhere in the country. It is such a delight to be here attacking these incredibly important, timely, and somewhat controversial topics this morning. I'll keep it this morning because that's what it is to me. So, we're going to have presentations from our three fabulous panelists. And I asked our panelists to, before they talk, just talk a little bit about what brings them to this topic. Because, as you know, Lila directed you audience members to people's bios, but I also think it'd just be nice to hear in this discussion sort of what brings us here, because this is an area where the work you've done in it and sort of the work you've been doing for years can be significant. So I just want to say, as Lila said, I've been working in the sort of intersection of technology and the law since for as many years as for many years, and in 2000 I wrote an article called Comparative Institutional Analysis in Cyberspace, which was about intermediary liability for third-party defamation, which is a mouthful. But it was about, at the time, the passage of the immunity under Section 230 of the Telecommunications Act of 1996, which is still in place and which grants providers and platforms immunity for the speech of third parties. And so that's something that we'll talk about probably a little bit as we go along, which is the principle that it established a principle in practice at the time that it was so important, and it's to the flourishing of new technologies on the internet and to speech on the internet, that that providers not have to take down speech of users and not be responsible when that speech is, in that case, defamatory, that they were provided immunity that they would not have in the same context offline. Now, it's a much more complicated thing, and part of it is there was just so much speech that intermediaries are dealing with of users, that part of it is just how would they do it? And it's a very big question. But in any case, at the time, not only was I looking at the legislation, but also looking at what are the possible other ways of handling that question besides legislation, and also how does the First Amendment regulate this question? But so that's my background, was sort of thinking about those issues. As we turn to the question today, I just want to, before we get into the presentation, also talk about the fact that what's difficult here is, as we think about providers, users, and the public, you have to think, and the First Amendment and laws, you have to think about, are you asking whether the providers have an obligation to permit speech of the user? So for example, if they take down a user's speech, is that violating the user's right? And if so, under what law? Maybe the user's First Amendment rights? Are you talking about whether the provider has an obligation to do something? As in the context I was just talking about, remove harmful speech, maybe to protect another user or to protect the public. So those are some things to keep in mind. Are you talking about a user's right to put something up on the provider, a user's right to be protected from something? And in each case, how does either an applicable law regulate that, or how does the First Amendment regulate an applicable law or not? So it's complicated, and I'll ask the speakers to, in addition to telling us a little bit about how they came to this question, try to avoid pronouns, because pronouns often get us into trouble. Because then we don't know exactly what we're talking about. So I want to start us off with Professor Hudson, because his talk today is a bit of a segue between the first panel this morning, because we're in the school context again. And Professor Hudson's going to talk about a very important case relating to the Snapchat cheerleader, and also telling us about how that case shows us the special significance of the First Amendment online, as well as the rules in school. So Professor Hudson, please.
Thank you, Dean. I first became interested in student speech issues when I joined the First Amendment Center back in 1995. So for about 17, 18 years, I wrote regularly on student speech issues in a professional capacity that led to law review articles and then several books on student free speech rights. I guess the main one was probably Let the Students Speak, A History of the Fight for Freedom of Expression in American Schools. That was published by Beacon Press. The personal interest I have was that I got disciplined for my speech in high school. So as someone who got in trouble for speaking out, that resonated with me deeply. And that's actually why I devoted most of my career to free speech. Did you want me to go on with the presentation? I didn't know if you were moving.
No, I'm sorry. Yeah, no. We're going. I'm sorry. Yes, please proceed with your presentation.
Okay, great. Let me try to share the screen. Hopefully I'll do that correctly. So I wanted to talk about the U.S. Supreme Court decision, Manaway School District versus BL. To set the background, the reality is that there have been several First Amendment free speech cases that the United States Supreme Court has decided. More than 50 years ago in Tinker versus Des Moines, the United States Supreme Court had held that it can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. That was really the linchpin case for student rights. And then over the next several decades, the United States Supreme Court cut back on student speech protections in a variety of cases, Bethel School District v. Frazier, where the court created a new rule, no vulgar and lewd speech. Hazelwood School District versus Kuhlmeyer, the court created a new rule for so-called school-sponsored student speech. And then in Bong Hits for Jesus, otherwise known as Morse versus Frederick, the Supreme Court created another Tinker carve-out for speech that school officials reasonably believe advocates the illegal use of drugs. So what we had was great protection in Tinker and then several carve-outs. And when the Supreme Court first granted cert in the Manaway case, a lot of people were concerned, but it's very important that the Supreme Court did this because, as we know, social media speech and online speech is really the new frontier for student expression. And if you look at the development of case law, you see that a lot of the emerging student speech controversies are where students post something offensive on Facebook or Snapchat or any of these various platforms and then get disciplined. The case itself involved a young high school student by the name then known as BL. We now know her as Brandy Levy. She was upset that she did not make the varsity cheerleading squad, and she was also upset that she did not, I think, get her preferred position of right field on a softball team. And so on a Saturday afternoon with a friend outside the Cocoa Hut, which apparently is a line of convenience stores in Pennsylvania. I've never heard of that in Nashville. But apparently she posts this Snapchat message with a fusillade of F-bombs. And, you know, I think she had 250 friends on Snapchat. One of those was the daughter of a cheerleading coach. They shared the Snapchat with the cheerleading coach, and Brandy Levy is suspended from the cheerleading squad for a year. You know, one of the most celebrated First Amendment cases is the F the Draft case, Cohen v. California. It's sort of ironic that in both of these F cases, the United States Supreme Court issued opinions that are fairly protective of free speech. But Brandy Levy sues. Her parents join the suit. A federal district court applies the Tinker standard. If you know the Tinker standard, it's basically reasonable forecast of substantial disruption.
David, hold on 1 second. Are you advancing the slides? Because I'm still seeing your title slide.
I'm trying to, as they're not showing up.
Yeah, no, they're not. It's still the title slide.
Oh, that's probably user error. Sorry.
No problem.
Let's see if I can fix that.
I just saw your slides earlier and know that you have several new ones to show us.
Yeah, I was trying to. I'm in practice at work. I must be.
If you would like me to share your slide, you can just turn this off and just tell me when to keep proceeding with the slide, and I can do that for you.
Yeah, could you do that? Is
Yep,
that cool?
you can just stop sharing. I'll
that.
take over. Okay.
Okay, appreciate it. So I'm on the slide about the federal district court ruling. And essentially what the federal district court did is that it applied the Tinker standard and found that, look, this off-campus Snapchat thing in no way remotely caused a substantial disruption. And so BL prevailed.
Professor Hudson, please stop sharing for the moment, and I will do my sharing of it.
Okay.
Thank
I
you.
don't even see where that
Should be on the top. Should be a stop share.
It's very top of the screen. At the very top of the screen, it says stop screen share. There should be something green.
I don't even see that on here.
I will. I will just.
There we go.
Yep. Good.
Oh, there we go. Okay.
And you can keep speaking.
Okay.
I will just catch.
Okay, sorry. So the case is appealed to the Third U.S. Circuit Court of Appeals. And the Third Circuit Court of Appeals also rules in favor of Brandy Levy, but they make a very broad ruling that school officials really don't have jurisdiction over off-campus online student speech. They also, as an alternative, say it doesn't cause a substantial disruption. It's a very broad ruling. So the case is the school district appeals to the United States Supreme Court, and the United States Supreme Court hears the case, and the court rules in favor of Brandy Levy, as did both the federal district court and the Third Circuit, but they recognized that they didn't want to go as far as the Third Circuit did. And so Justice Breyer, in his majority opinion, said that school officials do retain some regulatory interest over certain types of online speech, like harassment and bullying and things of that nature.
David, let me stop you for 1 sec, because I think it's really important before we go on to the Supreme Court.
Yeah.
How was the Third Circuit going to just make this line between on-campus and off-campus speech? Because when they had this stark line between saying the school district can regulate on-campus but not off-campus speech.
Yeah, so they had a really strict line that if it didn't take place on campus, if it really wasn't geographically taking place on campus, and took place on social media, that in most instances, perhaps other than threats, they did kind of qualify that if there were true threats, that it was simply that Tinker didn't apply, and it was beyond the regulatory arm of school officials. Yeah. So what Justice Breyer said is, while the school officials do retain some regulatory interest over speech, he identifies what he refers to as 3 features of online student speech and off-campus speech that reduce schools' regulatory interests. The first one is that the doctrine of loco parentis applies barely, if at all, with regard to off-campus speech. It goes so far as to say, as geographically speaking, if it's off-campus speech, in this case, off-campus online speech, parents have control. It's a parental disciplinary matter, not a matter of school discipline. The second feature, the next slide, and the second feature that Justice Breyer identifies is he points out that if we are really going to give school officials jurisdiction over all this vast array of student social media speech, then we're really turning school officials into 24-hour, 365-day-a-year school monitors. And that's just not practical. And furthermore, that would lead to school officials censoring a lot of controversial political and religious speech, which is speech that is at the zenith of First Amendment protection. And then it's the third feature that Justice Breyer identifies that really had a lot of student speech advocates jumping for joy. This is the next slide, where he says that, look, school officials have a duty to actually protect unpopular student speech. He's got this great line, America's public schools are nurseries of democracy. Goes on to quote the famous quote attributed to Voltaire, quotes the marketplace of ideas. It's really this sort of pie in the sky, great First Amendment rhetoric. A lot of us are already quoting some of his stuff in actual student speech litigation. So what do these 3 features mean if we look at them together? And this is the next slide, where essentially what it means is that school officials have less regulatory interest over a lot of this off-campus online speech, and that a lot of student social media speech is entitled to First Amendment protection, that it should be hands-off for school officials. The Supreme Court then also, and this is the next slide, talks about the fact that BL speech does not fit into these traditional unprotected categories of speech, right? She didn't engage in fighting words. That's traced all the way back to Shaplinsky v. New Hampshire, 1942, words which by their very utterance inflict injury or cause an immediate breach of the peace. What did the court say in Cohen, right? Cohen v. California. Cohen could wear the F the draft thing because it wasn't directed at a particular listener or speaker, right? She was just venting. She did not say F teacher so-and-so, F dean so-and-so, F professor so-and-so. It was just a generalized venting. It also wasn't obscenity, right? It wasn't in any sense erotic. It was just using the F word as an amplifier. And so ultimately what the court said is this is pure speech. Now, if we go to the next slide, one of the things the school said, well, don't we have an interest in teaching students the boundaries of socially appropriate behavior? After all, that's what Chief Justice Warren Burger wrote on July 7th, 1986, in the last opinion that ever wrote before the US Supreme Court, that we have to balance controversial and unpopular student speech against society's countervailing interest in teaching students the boundaries of socially appropriate behavior. Well, guess what? She did this at the Cocoa Hut off campus. So guess what? Your anti-vulgarity interest diminishes quite significantly.
Professor Hudson, It's all, isn't, and part of it is that they had never, there wasn't a school plan to try to address vulgarity, right? This was the only time they were really trying to address vulgarity.
Yeah, it makes it look like it's sort of an after the fact, post hoc justification,
Right.
right? Any way to try to win. Exactly.
But I
Excellent point.
just wanted
Plus
to, sorry, go ahead.
Yeah, plus the Fraser case has been limited, right? So initially, if we look at the iteration of the Fraser rule, right, no First Amendment protection for vulgar, lewd, or plainly offensive speech. Well, Chief Justice Roberts lops off the plainly offensive and bong hits for Jesus, because he said, after all, much political and religious speech can be considered offensive by some. And then the court also lops it off, as several lower courts have, saying Fraser applied to speech that occurred at a student assembly. It doesn't necessarily apply to speech that takes place off campus, and certainly not to everything that's on the internet. I mean, there's a lot of profanity on Twitter, after all, right?
Yeah, and that's why I wanted to back you up for a second, because when you were saying before, it's not fighting words, it's not obscenity, it's not a threat, it's not incitement. Because I think we need to really keep our eyes today on, what are some possible exceptions, right, to this great First Amendment protection for online speech. If he had said F the principal or F the coach or F the dean, that wouldn't really cross over, would it? Unless it were some kind of a threat. Or do you think it would? I mean, I know I don't want to really derail you, but I just
it would be a closer question. It would be a closer question, correct? I'm actually working on a law review article right now where I'm looking at the fighting words doctrine as applied to juveniles vis-a-vis adults. And unfortunately, the fighting words doctrine, even though the U.S. Supreme Court has not sustained a conviction in a fighting words case in Shaplinsky, there are quite a few convictions in disorderly conduct, breach of the peace cases in the lower courts. And a lot of people, I don't think, realize that. I think Breyer's opinion, as great as Justice Breyer was, I do think sometimes he did not lay out very clear, definitive standards. And I think this case is probably an example of that. So students, it's a closer question.
Don't say that online.
Yeah, right.
Pull back.
Right. I think look at the next slide. Parental rights are also at play here as well, right? There's just the thinking that when it comes to off-campus online student speech, it should be parents who are the primary disciplinary individuals, not the school. Next slide. The school also argued, well, this is an extracurricular activity. Look, the interest in speech here is not as great because the punishment's not as great. We're not actually kicking them out of school for a period of time. We're just saying you can't participate on the team. And nicely, the United States Supreme Court rejected that as well, right? That can still be a very negative impact. And we know about the importance of extracurricular activities from our own high school years. Mine harder to remember now, but it's still important. What about this general notion of morale, right? That somehow the speech would be harmful to morale. And the court there said, look, there really is not much evidence of this. In fact, one of the cheerleading coaches actually admitted in deposition that the speech didn't cause a disruption. So I think that was a very significant admission that the student attorneys used quite effectively. Next slide. What about the importance of the speech in question? The argument is that this is not really that important of speech. I thought Breyer had a great answer to that, right? Sometimes it's necessary to protect the superfluous in order to preserve the necessary. That's quite similar to what Justice John Marshall Harlan II said in an opening line in Cohen v. California. Next couple slides are about Justice Alito's concurring opinion. And while sometimes in the First Amendment world, Justice Alito has not been terribly protective of free speech, if you go back and look at his time on the Third Circuit, when it came to student speech, he at times was actually quite protective of student speech. He has a line in there that I will think will be significant for cyberbullying statutes and challenges to those, where he said, look, it's very difficult to craft a speech regulation that criminalizes bullying or harassment. So I think that's a very significant thing moving forward.
Well, Professor Hudson, how about this case in the case in Doe versus Hopkinton Public Schools, where the First Circuit applied Mahoney and said that the students off-campus anti-Semitic Snapchat posts could be punished.
Yeah,
And
so what's
failing
very
it.
interesting is I know I may not have the exact count correct, but I have found 6 federal court decisions post Manaway, and in every single one of them, the student has lost. And so that may be that courts are seizing upon that language in Justice Breyer's opinion, where he emphasizes that if something involves harassment or bullying or threats, that schools do retain some regulatory interest. Now, most of these are federal district court opinions, and I think most of them are on appeal. And so hopefully we'll start getting some federal appellate court decisions that kind of, I think, are more in line with the spirit of the Supreme Court's decision in Manaway. But so far, the courts are ruling in favor of school officials in a lot of these cases. And that's a trend.
Yeah.
That's a trend.
So maybe if you wouldn't mind wrapping up in about a minute or two so we can.
Yeah, so real quick, Justice Thomas dissented. And that's not a surprise, because in his separate opinion in Morse v. Frederick, he called for the overruling of Tinker. He dampened that somewhat, but he went back to his old famous case of Lander versus Seaver, where the kid makes fun of his teacher, calls him old Jack Seaver, and gets rawhide whipped, and that's okay because there's no First Amendment, and kids don't have First Amendment rights. The remaining slides are just 4 hypos, and hopefully that can be sent to the presenters and they can look at those hypos. My basic wrap up is I think Manaway is very important because it's the first time that the U.S. Supreme Court has spoken on the social media speech of public school students. And it said, look, a lot of times, at least, social media speech by public school students is hands off. And perhaps most importantly, I think Justice Breyer in Manaway breathed life into the spirit, the animating spirit of Tinker.
Thank you so much. Thank you. Very, very interesting, and obviously a very important case because, Tinker's an old case. And also it's an important case because, as you say, schools have been thought to have this, regulatory interest in maintaining, I don't want to say order and discipline, but making sure that there's not undue interference with their pedagogical mission. But at the same time, as you say, how does that translate when you leave campus, right? And one of the reasons that I was asking earlier about, how do you make the line between off campuses and on campuses? What do you do now with so much remote learning, right? So it's a really hard line to draw. So on the one hand, I'm sympathetic to allowing the school to have some power, quote unquote, off campus. On the other hand, I agree with you, Professor Hudson, that the Supreme Court, at least in a lot of its language, suggested that, certainly with nurseries of, what is it exactly?
Nurseries of democracy.
Nurseries of democracy, that we have to be very careful. And I think the other thing was the 24-hour, that if the school is going to have the ability to regulate student speech, particularly online, then that may preclude the student from speaking at all, right? Because that's 24 hours of their lives. So, so really difficult things to balance. And thank you so much for telling us about that case and explicating.
Yeah, and Dean, real quick, you made just a really great point that I missed. Both Justice Breyer in his majority opinion and Justice Alito in his concurring opinion both mentioned about online learning and said schools may retain regulatory interest there. So thank you for that.
Well, and I think our students are very conscious of it because they just did 2 weeks online because of the Omicron, and we're now thankfully coming back in person, but we've had to do both, right, in recent times. So, okay, and so thank you so much. Now we're going to go to my good friend, Professor David Green, who has for several years been an adjunct professor here teaching a First Amendment seminar. And Lila mentioned in the introduction that I've worked with the ACLU over many, many years. I've also worked with the EFF and really enjoyed that work, and worked with David and his group. So Professor Green is, as well as Professor Hudson, a First Amendment expert. And he's going to tell us a little bit about his background before he helps us disentangle all of the laws related to platform responsibility and user rights in the area of the First Amendment and speech, online speech. So thank you, Professor Dean.
Thanks. I'm really happy to be here. I always enjoy doing programs for USF, which I consider one of my homes. So just to respond to the first prompt, I started doing First Amendment work pretty much exclusively about 25 years ago now, and my first job doing it was actually representing the avant-garde arts community and avant-garde artists in free expression challenges, both as a lawyer and also just as an advocate for them. And that experience of representing that constituency of artists who found that their channels for communication were so narrow that even the smallest limits on them could be catastrophic for the ability to communicate, and whose speech was almost always unpopular. It still has stayed with me and still guides a lot of how I view both First Amendment law in general and the work I do in particular. That really, in the late 90s when I was doing that, that really sort of led me into sort of the world, the digital speech world, because what the internet presented at that time was at least fewer gatekeepers. And avant-garde artists really needed fewer gatekeepers. They were among the communities that really had been disadvantaged by having to either have popular support or monetary support behind their speech. And the internet was a great opportunity for them. And so I started doing a lot of work at that time and was one of the founders of the Internet Free Expression Alliance, based on the ideas that we really need to at least preserve some space in the online world that had the ability for users to try and communicate as directly as they could with the rest of the world. And again, I still carry that with me now. My current work at EFF generally, and me in particular, we like to say that our work is user focused. That our main constituency are internet users. And again, that is the case. And that's and that really does inform what I'm going to talk about today. But I also recognize that many times, maybe always, the interest of individual internet users can also be completely in conflict. So, somebody's right to speak, one user's speech on the internet might cause harm to another user. And so these are all very, very difficult questions and very compelling questions. And in fact, one of the reasons I always loved doing First Amendment law, aside from the fact that I believe in it very deeply, is that it's hard. And it's hard and it's challenging. Which leads me to the topic today, which I said I would talk about, which was previewed, is sort of just the legal landscape around challenging this idea, both the legal landscape and maybe also sort of the policy landscape around should these online interpersonal, we all rely on intermediaries for the internet. There's nothing the vast majority of us can do to communicate through the internet online without relying on some intermediary. Right now, we're relying on Zoom to do so, but I don't code well enough, nor do I own a web domain to be able to communicate directly. I rely on email providers, I rely on web hosts, I rely on my internet service provider, I rely on the various apps and services I use to publish. There's really nothing I do online that doesn't rely on a whole series of intermediaries. And so we have this question that comes up, and it's being really framed currently in the context of social media, but you could look at it sort of more broadly, is, what do these intermediaries, do they have an obligation to carry user speech, to publish all of the user speech that the users want to publish? And it's in some ways, in some aspects, a very easy question, and in some aspects, a very, very difficult one. I do want to say, just picking up on something that happened this morning. One of the things I think we came out of the first panel was this idea that it often gets said that sort of the First Amendment really supported the civil rights movement in the US in the 1960s. I actually really tend to look at it the opposite way, where I really think what you see is that the major steps the US Supreme Court took in developing First Amendment jurisprudence in 1960 was really in civil rights cases. And I actually really see that our major expansions in First Amendment law really grew out of civil rights cases, of cases like New York Times versus Sullivan, which I think is
NAACP.
too often framed as a press case and not a civil rights case. I think it's primarily a civil rights case, as well as NAACP versus Claiborne Hardware, the right association cases like NAACP versus Alabama, NAACP versus Brown. And so I really think when you see these major leaps, it was the civil rights movement really supporting the development of First Amendment law. And I think that's really important when we think about a lot of the issues that were raised in the first panel. I do think it's possible to have within our existing First Amendment doctrinal framework to advance goals of equity and equality within our existing framework. I think courts don't do a great job of doing that, but I do think it's possible to do without sort of completely rethinking how we think about the First Amendment, or even devaluing the idea of freedom of speech as a value. So anyway, I sort of said that because I think part of how my view on this sort of withdraws on some of that. I also just wanted one other thing to say before I launch into the topic is that one of the things that was said in the introduction was that there was a time when internet companies had a complete refusal to regulate user content. And I don't think that's true. I don't think there really ever was a time when they didn't regulate user content, and certainly not a time since the sort of commercialization when you actually start using commercial services. They've always regulated user content.
What about the earliest days of America Online?
Yeah. They what they didn't do was regulate user content that most people cared about the regulation of. But I think for disadvantaged communities, for historically silenced communities, their content was largely silenced online from the start, the same way it had been silenced in every other forum for them. And this was something I saw really, quite a bit at working with avant-garde artists, right? They had as many ops. They had, again, there were fewer gatekeepers, but there were some gatekeepers, and they did actively, and they did try, and they're trying, whether it was avant-garde sexual expression or what was considered sacrilege, anti-religious expression. These were things that were there were active attempts to monitor them. And I still think we see this now. In fact, I have an article coming out soon. If you look at even sort of the social media sites that herald themselves as big free speech, who work all about freedom of expression, Substack did this yesterday, they almost all exclude completely legal sexual expression. And I think and it's very easy for people who that's not what they want to speak about to feel like these are free speech forums, but for people who actually want to speak about and communicate about unpopular sexual expression, they actually feel they've always felt highly regulated. So there's always been there's these sites, especially the social media sites, especially the big ones we talk about, have always regulated user content. They may do more of it now. They may do more that you feel that's more palpable to an average user on every day, but they've always done it. They've always curated user content.
Yeah, and just for one sec, just to be clear, when we're talking about the providers, whether it's Facebook or Twitter or Google or whoever regulating speech, we just mean making their own choices through their terms of service or their practices or whatever about what stays online and what doesn't. And it's not what we usually think of as regulation, which is something passed by a legislature or enforced through a court decision.
Right,
So.
that's right. I will try actually not try to use the word regulate, but try to use the word curate or edit to show that they're private decisions. And just quickly, I've used way too much time with my introduction, so let me run through my substance really fast. We see there's a lot of, first there was a wave of private lawsuits of tort actions against sites by people who, like, Twitter or Facebook had either taken down their content or frozen their account or YouTube demonetized their content or something. There's a wave of these private lawsuits trying to establish some type of legal obligation for these sites to carry their content. We've now seen legislation attempting to do the same thing, both from Florida and Texas. There's a bill in Georgia that looks like it's about to pass. But the legal theories to try and establish a legal right that Facebook must post your post without any interference or any editorializing about it, requires that they establish some type of state action by these private services, because in order to claim First Amendment rights, they're going to have to find that they are sort of acting in a governmental capacity. There have been, I could say, 4 main theories to try to advance that state action right. And they sort of come in waves, and courts have rejected them. And then there's another wave. But just very briefly, the first wave was what's under the public function test of state action. This is what most of the original tort actions tried to do, tried to say that these sites were essentially public forums, the way that sidewalks and parks were. And so then those administering them could only impose reasonable content neutral time, place, and manner restrictions on them. Courts rejected that, really assisted by a Supreme Court case that arose in a completely different context, and said that it's not, to be a public function, it has to be an exclusive public function. And although governments do maintain public forums, they're not the only ones who do so. And so we've now seen fewer arguments around public function.
And that was partly because there's enough competition amongst these providers, right? Because you could go to Facebook or who else can you go
I mean,
to?
the courts didn't really rely on competition among the companies as much, but just the idea that public forums generally are not the exclusive realm of the government. So it wasn't really looking at the digital space and say someone who wants to speak on a social media, a highly infiltrated social media platform had options. But what they were saying was that just the concept of a public forum is something that happens both in private settings as well in public as well.
But just to be clear, so we're not imposing First Amendment obligations on these providers to carry speech because they are not operating as the government.
Right. And then the second theory another theory that was advanced was this idea of common carriage. This was really what underlie a lot of the Texas and Florida laws and was rejected by the courts. Both cases are now being appealed. And that's the idea that that's especially large social media sites are essentially common carriers, like telephone lines, and therefore have common carriage obligations. The courts, every court that has considered that argument so far, and again, it's been raised in these challenges to the legislation as well as in the tort cases, has rejected that argument, to saying they just don't actually bear the requirements of common carriage. The current one we're seeing now is more of a joint action idea, that these sites are collaborating with the government and essentially acting as the government, because the government may say something like, Center for Disease Control might say something like, that COVID misinformation is making it really hard to battle the pandemic. And so then Twitter takes down something as COVID misinformation, and says, you're collaborating with the government. Those cases so far have been rejected as well, with the idea that, and basically what the courts are saying is that it's still the private company making their own decision. The fourth one, which you haven't seen much in the US, but I see much in international courts, is the idea of that free speech, free of expression is a positive right. The idea that the governments actually have an obligation to preserve freedom of expression. And this would be a situation to do that. I used to say we don't ever see that concept anywhere in US law. But in the Supreme Court's opinion in Manaway, we actually did see something about a positive right of free expression. So we'll see how that gets carried. I just would say, to me, the main, I agree that that sites, even the big dominant social media companies who I have 1 million complaints about, I believe that they have a First Amendment right to curate and edit their sites, even if this disadvantages users, and it's going to actually tend to disadvantage users. Speakers always get disadvantaged, but I do think it's important to preserve they do have that right. They have the same right the way that newspapers have to edit and curate their op-ed pages, which are historically a mix of original and other people's content, the same way that bookstores do to decide what books to carry. I do believe they have that right, and I do believe it's important that they have that right and be free from government compulsion in that area. But what I want to say in closing is why I think it's important for users. I don't think that users actually would be happy with a social media system where internet sites were actually required to comply with the First Amendment and not have the ability to curate their sites in a way that they thought would be beneficial to users. In some ways, this is like both because we have some sites that really want to specialize. They want to be about crafting or running or kids' video games, just to name some examples, or photo art. I mean, some of the things that have hundreds of millions of monthly users, but are highly specialized services. They wouldn't be able to have those types of content specializations very easily if they're required. The other thing is that it would also disable, and this is my segue into what Victoria's going to talk about, it would also disable sites from being able to take affirmative action they want to take against what they perceive to be harassment on their sites, or abuse, or something that if they wanted to address user complaints about harassment, they can do that because they have a right to curate and edit their sites. So I do think it actually is the best deal for users. That being said, I also recognize that you're largely then making some of these big companies completely self-regulatory, and that's not always satisfying. It does put a lot of onus on us as users to complain a ton when they make bad decisions.
All right, thank you so much. And thank you for segueing us over to Professor Vilk. So just again, to clarify where we are, we've established very well, thank you so much, that the various theories under which a user can successfully complain really about having their speech restricted by a provider on the basis that the provider had a First Amendment right to carry that speech, or to not discriminate on the basis of content or whatever, those have failed. And so sorry, presidents and representatives who say they have a First Amendment right to speak on a private provider, you don't. And so now we're going to turn to the question of, do the providers, and should they, and how, I think Professor Wilk, have an obligation in some cases to exercise this freedom in a particular way. So they have freedom. Do they have any obligations? So we look forward to hearing your comments, Professor Wilk.
Hi, everybody. So I am Victoria Vilk. I have to say, I am an extremely distinguished company. I am neither a lawyer nor a professor, but I am the program director for digital safety and free expression. You asked me how I came to this work. Not that I mind being called a professor, it's nice, really, but to the question of how I came to this work. So I was born in the Soviet Union. My family fled when I was a child, and I come from a career in the art world. So David's work is very close to my heart. And so I have a very deep passion for freedom of expression that comes from both of those worlds, both where my family fled and growing up in dissident literature and seeing what happens when people said things they shouldn't, how the government reacted, and knowing that artists are often pushing social boundaries very hard and get into a lot of trouble for that. When I started at PEN America, if you had told me that I was going to create and run our online abuse defense program, I wouldn't have believed it, but that's what's happened because the problem has grown so severe in recent years. We are a nonprofit that celebrates and defends the written word in the US and internationally. And we have membership. So we have over 7,500 members who are writers, journalists, publishers, translators, et cetera, in every state across the US. And around 2015, 2016, they started reaching out to us saying, I am getting death threats and rape threats. I'm terrified to go online. It's impacting my ability to write and to do my job. Can you help? And so we did a study in 2017 of our own constituents. And we found that people were engaging in all kinds of self-censorship because of the online abuse that they were being exposed to. So they were changing how they wrote, what they wrote. They were taking breaks from social media platforms or shutting those platforms down, personally for themselves altogether. And they were fearing for their safety and the safety of their families. So, we are a free expression organization. And so that gave us a mandate to work on this issue. we first spent a year working with a bunch of lawyers, actually technologists, psychologists, and other folks to build a guide for writers, journalists, and others on what to do when you are under attack online. How do you protect yourself? And then the program just took off. And so now it's like my whole full-time job and then some. I have a team. So the core work falls into 3 buckets. We equip writers, journalists, and artists who are facing online abuse with self-defense training and resources. Like, what do you do when it's happening? The second bucket is that we collaborate with media organizations, universities, and employers to figure out how, through policies and protocols, to protect and support people who are facing abuse, right? So that the onus is not always just on the person on the receiving end, but that institutions have a responsibility to protect staff and freelancers who are under attack. And the third bucket, which is relevant to all of you into this conversation, is research and advocacy into social media platforms and whether or not they are doing enough to protect users from online abuse. I do think it would be really useful, because I'm coming to this with a somewhat specialized focus. I think we've been talking about free speech very broadly and online harms, I think, also very broadly. So I want to focus in on what do I mean when I say online abuse. At Penn, this is not a legal definition. This is a definition for lay people. But at Penn, we consider online abuse the repeated or severe targeting of an individual or group online through harmful behavior. And I'll drop a few links in the chat for you folks where we define all this stuff and map it out. But it's an umbrella term that involves a lot of different tactics. Tactics like, for example, death threats, threats of sexual violence, doxing, right? When somebody takes your home address, your cell phone, private information, publishes it online. Non-consensual intimate imagery, when videos and images, most often of women, are distributed that are sexually explicit without their consent. And I can go on and on about the kinds of tactics that we see that fit under the rubric of online abuse. But the question is, what is the impact of those things, right? It severely damages physical and mental health. It can. It makes people fear for their safety and the safety of their families. But as I started, pointing at the beginning, it actually also deeply suppresses freedom of expression and press freedom in particular. So our core constituency are reporters and writers. And I'm going to share in the chat real quick a study, just 2 quick studies that I feel like it's really important to know about for the purpose of this conversation. The first is from UNESCO and the International Center for Journalists, just from last year, where they surveyed thousands of journalists, female journalists around the world, and they found that 73% of them had faced online abuse. 20% had said that their online abuse migrated offline. Oh. So that's 1 in 5. And that many of those incidents became violent, physically violent. Over 30% of the folks surveyed were engaging in all kinds of self-censorship, some of whom actually left the field of journalism. So that's the first problem, right? And the second problem is that we know from many, many studies now that online abuse disproportionately impacts women, people of color, religious ethnic minorities, and LGBTQ folks. So that means that if we're talking about people being silenced, if it's particular groups of people that are being silenced disproportionately, it actually impacts the kind of this question that David very, I think correctly brought up of equity and inclusiveness on the internet, which is increasingly functioning as a public forum. There's a report that came out of Twitter, not out of Twitter, forgive me, about Twitter, that came out of Amnesty that found that Black women were 84% more likely than white women to be mentioned in abusive tweets, which is, again, a crazy number if you think about it. So the question is, like, what do we do about this problem, which has now become my full-time job to think about? I talked about the things that we're doing from the standpoint of user empowerment, from the standpoint of working with employers. But if the focus of this session is what do we do about platforms, I can say this: platforms have been abysmally bad historically at dealing with online abuse. And I will give you just a couple of examples. And this boggled my mind when we discovered this, but Twitter did not build in a reporting feature, like a way to report harmful content or abuse into their app until 2013, which is 8 years after they were created. Which like gives you a pretty good idea of like where in the level of priorities online abuse or online harm more broadly featured. And if you look at some of the track record of Facebook and Instagram and YouTube, it's just as bad. And so what we actually need to see is we need platforms to address this problem, both through policy changes, their own policy changes, and through product design. And I can talk very quickly about some examples of that. And then I want to end with questions to all of you about, like, are there ways that we can build regulatory frameworks around these solutions or not? And it's an open question because we at Penn are constantly internally debating and thinking through this problem. So here are a couple of examples of both policy and product changes. Here's a policy example. this happened last year. I spent 2 years working on this. Facebook has a public figures policy. Under that policy, public figures receive less protection from online abuse than other users, right? So if you are a world leader, the idea is people should be able to say more critical and potentially even abusive or offensive things to you and about you than a regular user, right? So like on its surface, okay, fine, that makes sense. Interestingly enough, they lump journalists and human rights defenders with world leaders in their public figures policy. So journalists in many, many parts of the world are often on the receiving end of government coordinated harassment campaigns. And so journalists were receiving less abuse from, less protection from online abuse in the same way as world leaders were. Does that make sense, what I'm sort of mapping out? Or do I need to, maybe it's a little bit, so there's a public figures policy, right? Under that policy, you can say much more critical and even abusive things about a president than you could about an average user. But journalists and human rights defenders were lumped into the same public figures category, which is to say they got less protection and support than the average user, when in fact they are lightning rods for governments to come after and for corporations to come after and for other people to come after.
And they don't have the protective framework that public figures do, right? Public figures
no, that's just it. They don't have intelligence services,
right?
The financial resources for support, right? Many journalists are freelancers. Many of them are often in direct odds with their governments. That's actually kind of the whole purpose, right, of accountability reporting often. And so it took us years to get Facebook to change that policy, and it happened last year. And they basically created a carve out to recognize that journalists and human rights defenders do not belong in the same bucket as world leaders with the entire kind of power of the state behind them when it comes to offering protection against abuse. But then they did another interesting thing, which is they said that actually, even amongst public figures, there are certain kinds of abuse that we will no longer allow that have to do with sexual harassment, sexualization, and other gendered forms of abuse. So that's interesting, right?
Like, so they're going to allow that kind of abuse?
They will not allow it anymore. They used to allow it. So even, no, but this is just it. But this is my point, actually, Susan. This has been allowed the whole time. Like you could, if you're talking about Kamala Harris, right? You could say things that were extremely sexualized, racialized, and that was not against platform terms of service because she's a public figure, right? And so that is one way in which policy reform within platforms policies themselves are changing. But then there's also the question of product safety. And that is actually where we've done a lot of work. And I'm going to drop in a report that I co-authored last year, which was a very detailed list of product design changes that platforms could make to protect users from online abuse. And we looked at proactive measures, right? How do you reduce exposure before people actually have to see abuse or before it happens? How do you reactively help people address abuse? And what are some of the accountability measures that you could draw on? And I won't get into the details of those here unless anyone wants me to. I can give particular examples of particular recommendations we made, but that gives you a sense, right? So what I'm basically saying is what we need from platforms is to tackle this problem, both from a policy standpoint and from a product design and user empowerment standpoint. But then the question is, like, do we need the law to pressure them to do this or not? And that's where I think that's like why this whole conversation is so incredibly thorny and difficult, because what I can tell you from my own experience is that if platforms do not have a financial incentive to build a feature or change a policy, they will not do it unless there is so much noise over so many years and such bad PR that they basically feel like they have no choice. But it's not something that's happening a great deal proactively in my experience. There is some of it, but it's rare. And so, I think a lot of what I've been thinking about is what are legislative alternatives to Section 230 gutting or Section 230 carve-outs? And I think we really, I don't know if this is the right forum, but I do think we need to talk about alternatives, like, for example, federal privacy legislation, right? If we made it more difficult for companies to surveil us, sell our private data for targeted advertising, we are getting at some of the problematic business models that basically underpin these companies and their incentives to spread abusive and harassing content. But we are not then, it's in a way a content neutral.
Oh, Victoria, let me stop you. And
yeah.
Not to completely derail you, as I like to say.
No, please derail.
Why are you running away
from
Section 230 carve-outs? Because because I'm not, I don't mean you're running away, but but you went quickly away from them, and they really are the crux of it right here. And I'm sure that the Davids want to get into this with us. Which is, just a little background for our audience. And, Section 230, again, is this thing that I wrote about 21 years ago now. But back to the harm, right? So Victoria, as you're talking about it, if I'm a journalist and I'm being harmed by someone, the one thing is, and I'm sure you can elaborate on this, I can go after the person who's harming me, okay, problem. I may not be able to identify them, huge. That there may be no jurisdiction over that person. They may have no money, right? So they may be a bot. There may be a lot of them. I may have not a lot of money to do this, especially if I'm a freelance journalist. So then the question is, do we need the intermediary to come in and help? And isn't it easy for them to do in some cases, right? And so that's where the question of intermediary liability comes in. And what we have is the immunity provision of Section 230, which 3 years ago there was a carve out passed for sex trafficking, right? For under
that was a disaster. I think a lot of people would argue. Do you disagree, Susan? Or?
I don't, so I've been a dean since then, so I haven't done a lot of research on it. But what I read it in the summer, they had done a study and it was only used once, I think. So it hasn't been used. So why do you say? And I can see Professor Hudson's ready to come in. But let's move to first names. I think that's great. But Victoria, why do you say it's been a disaster?
Can I just emphasize again that I am A, not a lawyer, and B, I don't actually work on legislative advocacy within Pan America. So please forgive me if the depth of knowledge I have in terms of Section 230 reform is not at the level of sophistication of my colleagues.
We need everybody to be involved in this, so please.
So let me answer your first question is why did I move away from Section 230? And then I'll actually come back and tackle the core of what you're trying to get at. And then I'd like to hear other folks jump in. And forgive me that I jumped to first names. I'm happy to go back to Professor and Dean. So in the nonprofit world, we all
first names is great.
So I think my frustration with conversations around Section 230 is like the problem I'm trying to solve is how do you empower and protect people who are on the receiving end of online abuse? And the Section 230 stuff gets so fraught that we basically do nothing about it. And so I am really, really interested in what other legislative approaches that are less potentially disastrous from a free extension standpoint, and specifically from a press freedom standpoint, there are out there to try to tackle this problem. And I do hope we make some time for that today, but I'm more than happy to go back and actually talk concretely about Section 230.
Okay.
Yeah, please. Or do you want to turn to other folks first and come back?
David, I just know wants to say something about Section 230.
Please.
David Hudson, am I right? Oh, David, you're muted. Sorry. David, you got to turn on your sound, David Hudson, because you're muted. Yeah, just click on your name. Yeah, there you go.
Oh yeah, no, I'm enjoying the dialogue between you two.
Okay.
I don't want to disrupt the flow.
Okay, David Green, did you want to jump in?
I mean, I can talk a lot about Section 230 at the appropriate time. I could, okay. If you want me to say something now, I can. Otherwise, we can pick it up later. So.
Well, let me just follow up quickly with Victoria. When you say it's a mess, do you mean that, and it's fraught? It's very hard to get that legislation through, and it's very controversial. I mean, what's happened recently is, some people are pushing a 230 approach on the right to try to say that, to try to accomplish the thing that David Green said we couldn't do, which is force providers to keep up the speech of people who are taken down for what seemed to be their political views, although it's really, so for example, if you think of the former president, the reason that he was taken down, I believe, was stated that it was because of incitement. His speech was dangerous. But some people are saying, oh no, it was a political reason. And so we need a law that says providers can't take speech down for political reasons. And then of course, what's neutral, right? What's a neutral non-political reason? And so you can imagine that people get scared for good. And this is part of the whole First Amendment problem in the first place, right? Which is, are we going to really let the government decide what's neutral speech? Because, the government today versus the government 2 years ago, And so then the question is, how do you define these things that you can carve out that are not going to be problematic? And again, we have defined sex trafficking, which I think we can agree on. We do have carve outs for copyright violations. There are the carve outs that David Hudson talked about earlier around, fighting words and threat. Some other types of proposals around Section 230 has been, maybe we can distinguish a little bit on sponsored speech, where sponsored speech we can regulate more because doesn't get to the heart of pure speech. Maybe, obviously there's some private takedowns around false speech, right? False speech around things around vaccines that have been false, but none of that's really getting to what Victoria is talking about and what the panel this morning is talking about. And I think this is where we want to pull David Green in, which is about speech that inhibits the speech of others because it's harmful. And particularly to the extent this bullying, harassing speech is subordinating people, women, people of color, religious and ethnic minorities, people with non-traditional sexual practices, as David was saying earlier, their speech is being inhibited. Isn't there some obligation to take something for government to do something affirmative? Can we do that? Can we?
Yeah. So I absolutely do believe there is an obligation. I think my question is reforming, gutting Section 230 altogether or making carve-outs in it the right way to do it? Or does that risk harming the very people it's intended to protect? And so I'm not going to skirt this, I'll get into it. I mean, so as a free expression organization, PEN America, I would say, as an institution, believes that Section 230, the advantages it offers pretty strongly outweigh the concerns that we have about it. And what I mean is that it's very difficult to define, and my sense is legally, it's actually very difficult to define bullying and harassment. And it's actually very difficult in the US context even to define hate, but it's really, really difficult to define harassment and abuse. And so I have concerns, for example, like when we look at Nigeria, right? There are cases in Nigeria where the government is now suing reporters and jailing reporters because their reporting is harassment. And it literally fits under cyber harassment law that's been written in such a way that it allows the state to come after. And I understand the issue here that there's this extra layer of platforms, but I guess, we're also seeing in many, many countries, governments essentially holding staff members of Twitter, Facebook, and other companies semi-hostage, right? They want a physical body in the country, like a person, whom they can threaten to get the company to take content down or to leave content up that they, strategically want up or to take down. It's a big problem in India right now. And so I think that I think I get nervous at the prospect of doing the carve out right. Like I believe in principle that you could do it, but I get very nervous at the prospect of how to do it right so that it is not turned around and immediately used to say prosecute, to basically force companies to delete journalism by reporters of color, for example.
Yes. And
that's what makes me really nervous. And so that's why I say, I am very confident that there are other legislative solutions to this problem that could potentially be significantly more powerful than gutting Section 230, which for some reason we never talk about. Like we're always focused on the Section 230 debate because it's a very interesting one. And the platforms, I feel like, kind of want us in that area debating that. But maybe the question is, what else can we do?
We'll do this.
Yeah, we'll stay there forever, right? And have civil rights organizations and free expression organizations and tension, when in fact there are so many things we could do that get at much more fundamental problems to the way these platforms are built and how they do their business that could potentially protect people much more effectively against abuse. So those are some of my broad brush feelings, but I would actually be very curious to hear from both Professor Hudson and Professor Green about, and also, I don't know if Professor Green's willing to talk about Sesta Fosta. I can try, but I suspect you might know more about it than I do, but about why that went deeply wrong. But I will try if Professor Green.
Let's do this. Let's hear from David Green about the Section 230 question, and then let's take your advice, Victoria, and get off of it, because I don't want to get into the cesspool that you mentioned. It is. I think there's, and this is what I wrote in 2000, although the piece was really about comparing the various institutions' ability to handle this problem, Congress versus the courts versus the market. But let's talk about alternatives to handling this very important problem you've identified, besides Section 230 and maybe even besides legislation, because it's a huge problem and it has to do with, you know, speech on providers networks. That's problematic. Okay, so first, David, who is in his car but very graciously talking to us by phone, please let us know your thoughts, David.
Yes, I'm sorry you don't get to see my video, but I had the airline sort of switched up the schedule on me. So anyway, I'm happy I can still participate. Just really briefly, to me, this an area of abuse and harassment is an area where Section 230 is not the problem. The problem is that much of the speech we don't want on the internet is largely legally protected speech. And so all Section 230 does is allow an avenue for liability, but there's other obstacles to liability, and a lot of that is the First Amendment. And so by what you're going to get by just opening up the courtroom doors for Section 230 are just a lot of lawsuits. What we see when you open up the courtroom doors for lots of lawsuits is the type of lawsuits brought by people of power to suppress speech they don't like. This never ends up being to the advantage of the people we are trying to help. So I don't think Section 230 is the issue here. I do think there's a good discussion to have about whether the law around abuse and harassment, the underlying law around abuse and harassment, needs to be reformed. But until that happens, Section 230 is not going to help do that. And it really is Justice Alito's opinion in Sachs when he was on the Third Circuit that is, I think, that declared much abusive and harassment speech to be protected by the First Amendment. That I still think is the main, is one of those things that has to be looked at. I don't think it's going to be looked at by this court because he's on this court. So anyway, the thing you get, just very briefly, what if you would take away Section 230, you would end up with two situations. One is that service providers would be required to look at every piece of content before they post it to make an assessment of whether it was risky to publish it or not. That would both slow it down and interpose them in between all of our communications, which I don't think is good for us. I think they do an awful job of doing it. And what they inevitably would do would be to take down way too much stuff. And when they take down way too much stuff, they're taking down the stuff that is written by people who have no other avenues to speak. So this always ends up hurting disadvantaged and minority and oppressed voices. The other thing you'd have would be a notice and takedown speech where they would be legally required to respond to every complaint they got. That's also not manageable in terms of scale, and it's also subject to great abuse. I think we see this in the copyright realm, which does have a notice and takedown scheme, where we just a tremendous amount of trolling, a tremendous amount of those with both money and power abusing that system to take down speech they don't like, because the power of just notifying someone that the speech is bad essentially means that it gets taken down. So anyway, that's what you get when you get rid of Section 230. Sesta Fosta, which I'm on the legal team challenging the constitutionality of, I think is both an unconstitutional law under the First Amendment and a really bad policy decision. And it's done exactly what everyone said it was going to do. It caused internet intermediaries to completely over-censor and remove a ton of sexual content, essentially taking sex work advocacy off of the internet and off of social media, forcing sex workers themselves back on the streets. Anyway, law enforcement, like city law enforcement, doesn't like it. I think it has been that Congress has actually asked for an audit of it to see if it's actually been effective or not. It's certainly not a good model for any type of legislation moving forward.
Good to know. Good to know. Okay, great. So, yeah, and so as you know, it's so difficult with anything affecting speech, right? The unintended consequences, right? And that's what we're trying to figure out. And certainly, it's so interesting that Victoria comes at this again from a free expression organization that then has to work in this area she never expected to. Okay, so what are we going to do about advancing civil rights online in this context and protect? And I just want to throw in another piece, which is protecting this country from misinformation and protecting us from and protecting our democracy. How do we do that with these platforms? There was an article recently where the person who has since resigned from the position, but was in the position of running Facebook's political, she interacted with all the political parties. She ran the elections part of Facebook. And she said that she thinks that Facebook has done more good than bad in terms of elections, but it's 58-42. No, sorry, 52-48. So very close in terms of how Facebook's contribution to the health of our democracy via the information it puts up around elections. And she said that a lot of the protections she put in place or would like to put in place for 2024, they weren't interested in. So with the free speech very much on our minds, and the laws that we know and the practices that we know, how do we maintain our democracy and protect civil rights and civil liberties? David, you said you had some ideas. Victor, I know you've been thinking about it. We have two Davids. And David Hudson, there's a question for you in the chat that maybe you could answer. It's directed to you in the Q&A. David Green, I'm putting you on the spot. You have some ideas for how to advance civil rights that are consistent with the First Amendment. And you've said we've done it in the past, so we can do it again.
I'm going to need to defer just for a few minutes because I have to actually move locations. And
okay.
so I am going to let someone else speak until I can get to a point where I'm better able to unmute my phone, but
Okay.
Hopefully just a few minutes.
Okay.
Yeah, well, I think that's a great question about what to do about disinformation and false speech. It's a very difficult problem to tackle. If we look at what the United States Supreme Court said in Alvarez, you know, the Supreme Court rejected creating a wholesale categorical exception for false speech, right? And Alvarez was a guy, I think, out west somewhere, Xavier Alvarez, who was on a water board or something. And he lied about just about everything. But he also lied about receiving military honors. And so he was prosecuted under the Stolen Valor Act. And essentially what the United States Supreme Court said is that his type of lies, his type of false speech was not harmful enough. And that the federal law in essence was too broad and criminalized laws that didn't cause great harm. So what do we do about false speech that does cause great harm? And I think that's where we have to have some type of materiality requirement in any sort of regulation, that it has to be something that causes substantial and material harm. And that has to somehow be proven before we can go down the road of censoring speech, because we run into these core First Amendment doctrines, one of which is that the First Amendment protects a political speech, right? A political speech is the core type of speech that the First Amendment was designed to protect. And we also run across a strand of First Amendment doctrine, and then this may come from the Gertz case, Gertz v. Welch back in 1973-74, about under the First Amendment, there's no such thing as a false idea. And then we also run into New York Times Company versus Sullivan, the seminal, and I agree totally with David Green, that's not just a free press case, that's a civil rights case that saved the civil rights movement. That case did, because so many media entities were facing staggering libel judgments at the time. But what did the Supreme Court say back in 1964? They said that oftentimes we have to protect some false speech in order to provide breathing space for speakers to speak out about controversial issues. That's not to say we shouldn't address this problem. We should. We just have to make sure that we craft narrowly tailored legislation that is specifically designed to speech that causes significant and material harm to elections. And we can't draft something that's too broad or too vague, or that would be used to punish unpopular viewpoints.
Thank you. Very, very helpful. Excellent. So materiality. Again, going back to the first panel this morning, maybe that's part of the answer, and taking us back away from elections, because it's a huger issue than we've really been dealing with, and it's so much on my mind, but I do think it's a little bit beyond what we've been talking about, although it's related. part of it, I think, is recognizing, again, that there are harms we haven't been paying enough attention to, right? And Victoria, what you were saying earlier is that, it's only recently that the providers have started paying enough attention to the harms of being sexualized, right? And sexually harassed, and how that silences. And I think as now with a reckoning in the racial justice movement and the Black Lives Matter movement, maybe we're paying more attention to the harms of people not being able to speak because of abuse. And so that will help us. And maybe we just need to not think about the providers for a moment, but think about just sort of changing the way we think about appropriate liability schemes. I don't know. Do you see what I'm saying there?
Yeah. Well, but I want to go back to the providers for a minute, and then I can talk about, like, if you set the providers aside and you're talking about like both criminal and civil ways of dealing with online abuse. But if you look at the providers, if we temporarily, so first of all, I dropped in the chat, if you want to hear some very nuanced and very clever critiques of Section 230 from lawyers who work, legal scholars who work on online abuse, take a look at Danielle Citron and Marianne Franks, because I don't want to do justice paraphrasing their work, but read it. It will definitely make you think. And I actually have, some of my own thoughts about some of what they're proposing that I think is really worth the debate. Setting that aside, if we set aside Section 230, I actually think there's an enormous amount we can do legislatively to pressure platforms to do better that does not involve having them blanket remove content off of the internet. And so, for example, mandating transparency. Right now, we don't really have a good understanding of how much content platforms inadvertently remove posted by women of color, for example. We know that they're removing more content from minority groups than other groups, but we have no idea how they make those decisions. Do they algorithmically downgrade content that they shouldn't be? There's so much we don't understand about how they prioritize some things and downgrade other things, and who is being impacted badly by that, except that there's enough studies that we can kind of tell who's being impacted the worst by that. So I think mandating transparency, because of course these platforms don't want to be transparent. In fact, so much so that they've actually been going after academic researchers at NYU and other institutions who are trying at the Markup, this journalism outlet that writes about tech platforms. They're making it very, very difficult for journalists and academics to dig into their practices, content moderation wise. So that's a place to start. Like, how do we figure out what they're actually doing? That's one thing. Another thing is, I said this at the beginning, but federal privacy legislation, there are two things that could do. First of all, this is the only country that I know of at the moment where data brokers can scoop up our private information, like Spokio white pages, and sell it for 5 cents on the internet. And that is part of how people dox one another and make people feel unsafe at home. But the other piece is, if we actually try to tackle the kind of surveillance ad economy, we can make a huge dent on what these platforms are prioritizing and not prioritizing. What I mean by that is, platforms at the moment make money through eyeballs, right? Like, the more eyeballs look at posts, the more people spend money, like the more companies will spend money on ads, right? Because they reach enough eyeballs. And so unfortunately, a lot of the content that does really well is often violent, abusive, aggressive, controversial. That's the stuff that travels and gets surfaced. So what would it mean if we actually tackled social media platforms from the standpoint of their ability to sell our private data, often without our knowledge or full consent, right? To actually go after the business model itself. And also, what would it mean to tackle them from the standpoint of antitrust, right? Like, what does it mean that we have a handful of companies that hold an enormous amount of power over the speech that's actually allowed or not allowed on the internet? So this is what I mean about how I think there are many, many ways that we could tackle the problem of online abuse and online harm, even if we're at a deadlock around Section 230.
Yes, absolutely. And there's a book that came out a few years ago by Roger McNamee called Zucked, which is about the problems at Facebook and why antitrust and breaking Facebook into smaller units is a good idea. And so I recommend that book, as well as the work of Danielle Citron and Mary Jo Franks and Benjamin Wittes. They have Danielle Citron and Benjamin Wittes have an article together about having the courts play more of a role in determining the suitability of online behavior, which is actually how they handle it in Europe. But David Green is back, and he's able to jump in, and we are going to let him have the last word. David. Unmute yourself, please.
Hey, can you hear me now?
Yes.
Okay, good. So thank you for giving me the last word. I want to go back just a bit to misinformation, which I think is a really difficult problem. I do think it's possible under existing First Amendment doctrine to craft laws and restrictions on the distribution of misinformation, especially in specific contexts like elections or public health. And I think those laws can pass strict scrutiny. I don't know that there's political will to do that, but I do think it's possible under existing First Amendment doctrine. As David said, I think you could show sort of have a requisite harm element in those laws. What I scared about is that when we see laws like that in other countries, we just see them being used for the opposite purposes of which they were passed. So again, misinformation laws tend to be used by governments in power to punish political dissidents, and tend to be used by rich people to silence their critics. And even the term fake news was the term of despots. It was the term that despots would use to silence their critics. So I think it's possible to go down that path. I just think what history and the experience of the rest of the world tells us is we have to be really careful when we do that. And I think that's sort of a theme with all restrictions on freedom of speech, even when we all believe that there's a problem and a harm that's not adequately addressed. We just need to be careful, because we are ultimately giving power to the enforcement power and the mechanisms of enforcement to those who are most likely to abuse it. Not exclusively to those who likely abuse it, but those who have the capacity to abuse it to a much greater extent than others. So again, these are worthy efforts, but they are fraught and they're difficult to do.
Yes, absolutely. Thank you so much. And thank you for continuing to engage with us as you go to the airport. And I will take back the last word to just say one thing substantively, which is, as Victoria was telling us, we do also have to look at other mechanisms besides the government legislation, which is being educated about what's happening and using market mechanisms and indirect mechanisms besides direct legislation to get the result we want. But I want to thank again our panelists so much. This has been a wonderful conversation. You're obviously extremely prepared for our discussion and very engaging, and sharing your expertise has been a delight for me and for our audience. I want to thank Lila Garlinghouse, who's here, who put together a fantastic symposium, and the USF Law Review for all their effort in making today happen, and for their great work all year. So thank you so much, everybody.
Thank you so much. I just want to jump in and say thank you so much to our attendees and our panelists. We're going to break for lunch from now until 1:10 p.m., at which time we'll be joined by our keynote speaker, constitutional law scholar, Dean Erwin Chemerinsky. So please also remember that the keynote will be conducted in a separate Zoom webinar, same as the two panels this morning. So leave this call and then rejoin at 1:10 in the third webinar Zoom link. Thank you so much to our panelists and to all our attendees. We'll see you soon. Thank you.
Thank you, everybody.
Thank you. Bye.